The race for Attorney General is a heated contest between Democrat Kwame Raoul and Republican Erika Harold.
So we asked each candidate what they feel is the biggest issue facing the Attorney General's office over the next 4 years and how they plan to fix it.
The biggest challenge facing the Office of Attorney General is using the office's resources to fight public corruption. Wherever I am around the state, people talk about the importance of having an Attorney General that will be a watchdog and will hold both parties accountable. I'll use the office's statutory authority to be able to investigate instances of public corruption. I'll also use the office's resources in the Public Access Counselors Bureau to be able to help enforce compliance with the Freedom of Information Act and the Open Meetings Act. People deserve an Attorney General that will hold both parties accountable and fight public corruption, and I'll make that a top priority.
The biggest challenge is dealing with assessing the resources for the office. The office has about $83 million budget, $30 million or so roughly coming from the General Revenue Fund, over $50 million self-generated. So the Attorney General's office actually generates revenue for the state at large. Question is whether the office itself is adequately resourced, whether the Public Access Counselor's office is adequately resourced, whether the office at large is dealing with litigation of in-state matters and national matters are appropriately resourced to retain the talent within the office to carry out all of the duties of the Attorney General's office to protect consumers, to protect victims of crime, sexual assault and domestic violence, to advocate for the protection of access to health care and take on cases against polluters of our air and our water.
The Attorney General enforces the Freedom of Information Act in Illinois, requiring transparency in government.
But lawmakers don't have to turn over their emails, so we asked each candidate what they push for legislation to make sure they do.
At this point in time, there are not aspects of the Freedom of Information Act that I'd be advocating to amend from an Attorney General's perspective, because the biggest challenge within the Public Access Counselor's office, within the Attorney General's office, is addressing the backlog that comes from the requests for advisory opinions as it relates to the Freedom of Information Act. And so I think in order for that statute to work most effectively, we need to address the backlogs of requests that are come to the Attorney General's office. And the best way of doing that is to provide the office with more resources, more personnel, because you want to have timely opinions issued from the Attorney General's office. And that's where I'd focus my time and energy as Attorney General.
You know, I think it is a debate worth having. The thing that we have to be very careful about is not to scare people away from engaging in the legislative process. You know, I think part of the reason why there is an exemption there is so that it can be a free and open exchange of ideas as the policy is developed, and we don't want to scare the people in the public at large from being able to have their private conversations with their legislators.
The issue of abortion has been a hot topic in Springfield and in our nation's capital. President Trump promising to overturn Roe v. Wade with his judicial picks to the Supreme Court. And last year, Republican Governor Bruce Rauner signing HB 40 to expand access to abortion in Illinois.
So we asked each candidate if the federal or state government pushed to limit access to abortion procedures, how might they respond?
Regardless of the issue at stake, the job of the Attorney General is to enforce law and to defend the constitutionality of Illinois law. So whatever changes that the General Assembly chooses to enact, if they enact them into law, it's the job of the Attorney General to defend the constitutionality of the law if it's challenged in court, and to uphold and enforce Illinois law. And regardless of the issue at stake, I will faithfully commit my obligation to do that and fulfill those responsibilities.
Well, I would advocate strongly on behalf of women to be able to, women of all levels of income, to be able to have access, full access to fully informed health care, including reproductive health care rights. I'm the father of a 18-year-old that I dropped off in the state of Missouri, which, you know, if Roe v. Wade were overturned, I think Missouri would be an entirely different state than the state of Illinois. I think Illinois is an oasis for women who would seek reproductive health care in the Midwest, and so I would advocate vigorously to protect that right.
Illinois has a long track record and reputation for corruption in government, and candidates running for Attorney General have long made big promises about how to put it to a stop.
But is it appropriate for a partisan political figure to prosecute a political opponent? We asked the candidates.
One of the tasks of the Attorney General is to use the office's authority to combat public corruption. And so if an Inspector General's report provides evidence of misconduct by a public official, it is appropriate if the Attorney General has jurisdiction to pursue that investigation, and I would certainly do that. It's important, though, to take politics out of the office so that any determinations that are made regarding investigations are done in a way without respect or regard for partisanship. Sometimes this office has been politicized, and people throughout the state of Illinois deserve an Attorney General who will make decisions based on the rule of law, what the Constitution demands, and without any respect to people's political affiliation.
Absolutely, it's appropriate, and the determinative factor is evidence. Evidence of wrongdoing. If there's evidence of wrongdoing of any public official of any party, it would be incumbent upon the Attorney General and the investigators and lawyers within to fully investigate that, and if the evidence points towards a criminal prosecution, to seek out to prosecute whatever bad acts that exist. So I might add that it's happened. It's happened, notwithstanding reporting that it has not happened. It's happened under the tenure of Lisa Madigan. She's prosecuted both Democrats and Republicans.
Now, whoever becomes the next Attorney General will have to represent the state in court.
And sometimes public unions will sue the state in negotiations. We've seen that in several cases. So how does an Attorney General decide which to represent, the state employees who work for the state or the whole state of all its citizens? We asked the candidates to explain their answer.
The job of Attorney General is to represent the state of Illinois if a lawsuit is initiated against the state. And so anytime there's a dispute where the state of Illinois is involved as a litigant in a legal action, it's the job of Attorney General to represent the state of Illinois' interests. However, there are other arenas where the Attorney General has more flexibility with respect to how to use that discretion. So in consumer protection actions, environmental actions, the Attorney General has greater flexibility to be able to balance a plethora of interests. But when the state of Illinois is sued, it's the job of the Attorney General to provide that representation.
Well, ultimately, you represent the people of the state of Illinois. And a lot of the captions of cases, it's the people of the state of Illinois versus such and such. So ultimately, you're representing the taxpayers of the state. But it's important to recognize that members of unions are part of this body of people of the state of Illinois. I'm the only candidate in this race that has actually been engaged in collective bargaining, representing a public entity. I'm the only party in this race that has actually defended grievances that might have been filed by members of unions or by the union at large when I worked as in-house counsel for the City College of Chicago, representing 7 community colleges. And in some cases, resolving the matter required recognizing that there had been a wrong. And so you seek out to settle the matter as quickly as possible in those cases. In not all cases where you're representing a client is your client in the right. And you got as an effective lawyer, you have to recognize those facts and seek to resolve a case as amicably as possible in the interest of justice.